I'm going to introduce Mark LeHocky, who is going to be our moderator for this program today. Mark, take it away.
Thank you, Ann. And I want to kick off by expressing my thanks to the Contra Costa Bar Association. And I think ADR Services, my organization, have also been involved in sponsoring this event. Thank you very much for helping to put this together. And thanks everybody for attending. I'm very pleased to share the program today with Commissioner Palvir Shoker, with Kate Mignani and David Ginn. And what we agreed to do was to spend a few minutes giving our own backgrounds. I think that's partly because Commissioner Palvir Shoker is afraid if I introduce her, I will bring up a lot of background that no one wants to share. No, only joking. So perhaps we could do some brief self-introductions, and then after that, we'll be going through some presentation materials, but we definitely want to invite any questions or feedback as we come along. We might address them in real time. We might sort of save them for later on, and then also reserve time for Q&A at the very end as well. So Commissioner Shoker, would you give us some background?
Oh, I knew you were going to do that to me. Hello, everyone. Unfortunately, we cannot see you because it's a webinar, but it would be great if we were in person. Then again, saying it from someone who is going through COVID right now, maybe that's a bad idea. But thank you for joining us today. This was a program that was being kind of talked about for a while. And then when Kate said, we need to do this program, and we knew that the time is now. And just as a quick background, this is a new position for me. Being a commissioner, I was appointed in November. So before that, I was a mediator where I had an opportunity to review declarations filed by attorneys. And before that, as an attorney myself, I did all those things that we're going to tell you today not to do. And many times did things right where, somebody reading the declarations that we provided and were told, good job. So been through all of that, done all of those things. So as Mark said, if you have any questions during the program, let us know. But happy to be here, and I think it's a great program.
Great, thank you. And Kate?
Thank you, Mark. So my name is Kate Mignani. If you see any of the pleadings that we file with the court, you'll see my name is Catherine, but that's really what I get called when I'm in trouble. So for today, I prefer to be Kate. Thank you, Mark. I am an associate attorney at the law offices of Joseph H. Wolch in Walnut Creek. It's a family law firm. Prior to that, I worked for the wonderful firm of Edrington, Schirmer, and Murphy in Pleasant Hill, and that was civil litigation. And I am a graduate of the University of California, Berkeley, go Bears, and the John F. Kennedy College of Law. It is my privilege to be on the education committee of the Contra Costa County Bar Association. And I really have to credit both David and Commissioner Shoker for the idea and the substance of today's presentation. It was David's idea when I said, we're looking for ideas to help attorneys in our county. And he said that he has encountered problematic declarations and he would like to help other attorneys to write better ones. And I thought that was very gracious of him. And then Commissioner Shoker kindly shared some of her observations from the bench regarding problematic declarations. And so I am grateful to be on the panel with them. And I will be talking a little bit later about the importance of truthfulness and civility. Thank you, Mark.
Oh, great. And David, I know we're going to turn it over to you, but before we do that, a little background.
Yes, thank you, Mark. I've been an attorney for, it's nearing 35 years now, goodness sakes. And I've been in civil litigation that entire time. My practice emphasizes real estate and construction litigation. So I'm pretty frequently in front of the courts of Contra Costa County. I have my own law firm. It's called GinnLaw, PC. And just moved to right next to where the Treat Towers are. So it's a nice new location. Don't be fooled by the trees behind me, by the way. I'm facing right onto Highway 680. You'd never know it by looking at it, but there it is. In any event, I live and work in Walnut Creek, and I have a 14-year-old son who's going to be going to his first year at Las Lomas this fall. So pretty excited about that. And I look forward to this. I really hope that this can provide the participants with some good information about preparing declarations.
Great. Well, thank you. And briefly, I'm Mark LeHocky. Some of you may know me. I've been practicing law for too long, so I'm not going to mention the number. I'm also going to disclose I'm recovering from COVID, so I'm sitting here on my back porch. I'm not even wearing long pants, but I can do that. I can get away with it. So quick background, 20 years as a litigator representing plaintiffs and defendants in large-scale cases, 12 years as a general counsel for different companies, and an overlapping, I have to be careful to say overlapping now 23 years doing different types of ADR work, primarily mediation, but also arbitrating and special master work and the like. And I do encounter declarations a lot in those different roles and definitely have my 2 cents to share as we go forward. I also Berkeley grad, went to law school there and now teach at Berkeley Law. Don't get me started about how they've lowered their standards for faculty, but we'll get back to that because part of that teaching actually involves teaching lawyers to approach the process differently, and love to hear the feedback. So what we all agreed to do was turn things over to David for the next 20 or 30 minutes to cover some material, and then Kate will add input to it, and we're going to get everybody's input, obviously Commissioner Shoker's input as well as we're moving forward. So David, take it away.
Great, thank you very much, Mark. I'm going to start by going ahead and sharing the screen here to get the presentation up here. One moment. Here we are. Just need this to slide down a little bit so I can. Oh no, here we go. All right. So anyway, what I want to talk about today is developing good and most importantly, admissible declarations and provide you with some tools, tips, and some tactics. And we're going to start by talking a little bit about the preparation of the declaration, focusing on the witness testimony. Now, we start with the basic elements that you have to have in an effective declaration, which is you have to establish a foundation, you have to provide authentication, particularly for documents, and you have to make sure that what your witness is putting into a declaration is actually admissible evidence. And one of the reasons why I thought this program would be good for all of us is because declarations are evidence and they are treated like evidence. And as Kate noted a little bit earlier, in our discussion, I noted that there's several motions that I've dealt with recently where essentially the declarations that were filed by opposing counsel were so bad that I just filed my evidentiary objections with my opposition. And there was really nothing left to discuss, because if you want to carry the day on a motion, you need to provide the court with admissible evidence that the court can base its ruling upon. And you'll note here, I have several cases here that really provide what I think is pretty obvious, is that declarations have to provide admissible evidence. And that's not as easy a task as one would think, because there are certain steps that you need to follow to get there. One of the real key parts, I think, to providing a good declaration is to establish the personal knowledge of the declarant, and the declarant is the person who is signing this declaration. And the way that you establish personal knowledge is important for really both a evidentiary reason, but also for a strategic reason. By showing that someone has personal knowledge, you get into the facts and the circumstances that establish the reason why this person has the ability to present this evidence. And by doing so, you also support the evidence, provide the importance to it. and demonstrate to the court why this is important for you to be paying attention to. What I often see in declarations is very little effort being given to essentially establish the personal knowledge of witnesses. And in fact, I'm going to refer to a couple of things that I see in declarations where I just sit there and go, oh boy, not a good idea. So let's go ahead and take a look at these things. Now, the first basic approach you always have to look at is establishing a foundation to all of the evidence that you present. And this is evidence 403, and this is evidence code section 403, and this relates to this whole issue of establishing personal knowledge. What you want to try to avoid is stating conclusions and stating the conclusion that I have personal knowledge of the fact and can testify isn't going to cut it. Instead, what you need to do is go to the extra step of actually humanizing the testimony. Treat a declaration like you are actually in court and you have a witness up on the stand. And when you have a witness up on the stand, what do they do? Well, they say, state your name for the record, and who are you, and what do you do for a living, and why are you here? What's your complaint? What's the issue here? You want to essentially give some texture to who it is who's testifying, because a witness just can't get up onto a stand and say, he did it, because everyone, the jury's all looking around going, well, what qualifies you to know that? And so we have to go through the process of establishing an adequate foundation in order for a declaration and the significant facts to be considered. What makes that happen? Well, statements such as, I was there, I was present at the time of the auto accident, or even better, I was driving in my car when all of a sudden I felt this pain in my back, and I turned my head and I looked, and a car was stuck on the back of my bumper, and I observed this. I got out of my car and looked at the back of my car, and my car was demolished in the back by a car. I mean, that is bringing this person. There is no question at this point that this person has the foundation to then describe what happened at the accident, what people said at the accident, because this witness has established the foundation that they were there and they were involved. And that's something that I think really needs to be a focus of what you do in declarations. Now, again, related to that is establishing the admissibility of the evidence that is presented. And when we're looking at admissibility, we're looking at the witnesses testifying to the things that they observed and that they saw. And be very careful about, of course, the hearsay rule. Now, of course, there's many exceptions to the hearsay rule. But when you get into a witness who's saying, somebody told me that, well, you should be sensitive to the fact that that may be subject to a hearsay objection. Now, of course, if it's a statement made by a party opponent, that may make it admissible, but try to focus upon what the witness knows, what the witness observed, and put it in those terms. And try to stick as best you can to talking about facts as opposed to conclusions. Something I see very commonly in declarations is a desire to just state the conclusion or state a conclusion. And conclusions are not admissible. The underlying facts that lead to that conclusion are the things that are admissible facts. So I have these case citations here for your reference, and I'll tell you right now, these are the case citations that I use in my objections to evidence. So, if you file a motion involving my office and you don't follow these rules, you can expect these cases to be presented front and center to the court. And you'll see here under, for example, this People versus Lewis case, the capacity to perceive and recollect is a condition for the admissibility of a witness. So if you're talking about something like, an auto accident, get your witness there. If you're talking about something like a contract, get your witness there. I was there. I was in the room. I watched, Mr. Jones sign the agreement. I then signed the agreement. My signature appears on this page. That's how you get evidence in, is by providing authentication and showing that the witness has personal knowledge of what's going on. Now, foundation is a related issue, and foundation essentially has two parts of it. The foundation establishes the reasons why the declarant is able to provide admissible evidence, such as I was there, I saw this, I experienced this, and then also the capacity. And don't forget about capacity, particularly if you're dealing with a declarant who's very old or very young. If you have someone who's under the age of 18, you should have a declaration that really kind of gets into the minor's ability and understanding and ability to essentially talk about what they saw, and keep the language suitable for someone of that age as well, I think is a good tip. And when you're dealing with someone who's quite a bit older, you do need to establish that someone is, they have the capacity to provide this testimony. And again, you do that by laying foundation about what this person saw and what they observed. And just by their ability to present these facts, they can establish capacity. But simply stating the words, oh, I have capacity to testify, that really doesn't cut it. And the cases concerning this are pretty clear. Now, I gave some examples of things that you see in declarations. I have two examples here. One is from an automobile accident case, and you have the person identifying themselves as a plaintiff in the lawsuit, and they say, I'm an adult male who's currently age 45, and I have a California driver's license. Okay, now that inferentially, since this person has a California driver's license, there are tests that are given to people if there's a question of their capacity. So that's an inferential fact that they have capacity to testify. And then we go on to provide the foundation. I was driving my blue 2012 Toyota Camry on the evening, and it goes on where I was, what direction I was traveling. All of these things establish the foundation that then this witness can go ahead and testify about this. Now, another example I have for you is an interesting one because it deals with the attorney's declaration. Now, attorney's declaration is something that's kind of an interesting situation. It is enough for you to state that you're an attorney at law licensed to practice in the courts of the state of California. Now, what the significance of that is that you have identified yourself as an officer of the court, and you are given a certain degree of leeway. You are allowed to present facts that you are able to represent to the court are essentially not in serious controversy. And then, of course, if you have facts that are of your personal knowledge, you can testify to that. But you can, for example, say, attached and incorporated here too is the contract that is the subject of this proceeding. Okay. Now, even though you're not a signatory, that's enough as long as the other side doesn't say, well, that's not the contract. And if that now becomes a matter that's in controversy, you're going to have a declaration that actually establishes the admissibility of the contract. But as to things that are not subject to a lot of controversy, an attorney's declaration can fill in the facts that are needed to be filled in. But just be careful because there are differing opinions as to what's in controversy and what's not in controversy. Now, I do want to emphasize something. I commonly see this in declarations where attorneys put in declarations, if asked to testify concerning the matter stated herein, I would testify the court. And that is a conclusionary statement. You can't say, oh, I'm competent to testify. That is a conclusion. Conclusions are not admissible evidence. Now, you can present facts demonstrating your capacity, but you can't reach a conclusion. If you state a conclusion and the other side raises the objection that it states an improper conclusion, the court will sustain that objection. And so these sorts of statements do not, in fact, establish capacity to testify. Okay. I do want to just note this Roy Brothers drilling case. I mean, if you read this case, they note that this statement is essentially a conclusionary statement, and the court is looking for facts to support what's stated in the declaration as to capacity. Now, another thing I see with declarations as a big no-no is to include a statement based on information and belief. I am informed and believe that on this date something happened. Okay, that statement has zero evidentiary value. Statements made on information and belief are not worth even putting into a declaration. Okay, you can put them into a complaint, but the courts essentially consider them to be wishful thinking, and they are not admissible evidence. And as I noted earlier, in terms of conclusionary statements, one of the big problems I see with declarations is the desire to reach conclusions instead of focusing upon the supporting facts that gets one to that place. And as I noted here, the Parker versus Otis case, a very old case, but it says a witness should be confined to facts and leave the conclusions to be drawn from these facts. And statements like, I did not cause the accident, that's a conclusion. Or I'm not liable for the plaintiff's damages. Similarly, that's a conclusion. Or this was one in a recent declaration I saw. This agreement is binding upon the defendant. It's like, witness can't testify that. That's for the jury or the trier of fact to decide. So you want to really focus upon the facts. And I'll tell you, when you provide a full and rich statement of facts, it carries the day. It really is a lot more persuasive than providing these kinds of conclusionary statements. So let's talk briefly about admitting documents by declaration. Now, in order to admit a document, you do need to authenticate it. And authentication means that you have to present it in a way that this document purports to be what the person offering the document says it is. And so if it is a contract, the way that you authenticate a contract is by, you say, first of all, and this is critical, you say attached is a true and correct copy of the contract. But then you need to authenticate it. You really need to now go to the next step, which is establishing the foundation for what this document is. I was present in my lawyer's office on November 20th of 2021. Present in that room was my lawyer, the opposing party's counsel, and Mr. Jones. I was there and watched Mr. Jones sign this document. After he finished signing the document, I then put my name to the document. Now this is providing, with that type of evidence, you have brought this document far enough so it is now part of evidence and would be admitted without really much controversy, unless there's an issue about contesting whether Mr. Jones in fact was there, or if that's really his signature, which does happen sometimes. So that's how you go about the process. Number one, you say it's a true and correct copy, and then provide the foundational facts to establish why it is you know that this is a real document. What about text? Texts are always problematic. Well, you can say, attaches a series of texts that were exchanged by myself and this other party. These were received to my phone number. You might want to state what your phone number is. I received these texts to this phone number, and I responded to these texts. And when you establish the exchange back and forth, you're providing the adequate foundation. And the same thing goes for emails. If you say, I received this email, I recognize this person's email address as being, this particular person, and I've exchanged emails with them in the past, that also establishes the foundation for authenticating these types of communications. But fundamentally, what the evidence rule is that the writing is what essentially someone claims that it is, as opposed to someone else. And look for statements and declarations such as my signature, I signed this. It appears on page 6 of this document. Or I observed Mr. Jones signing the document and handing it to Mr. Smith. Or I recognize the signature of Mr. Jones that appear on page 6 of this document. But don't stop there if you're going to do that. You then have to lay a foundation of how is it that you recognize this signature? Well, in this case, you say, I've seen Mr. Jones's signature on numerous documents in my position as his administrative assistant. From this, I've become familiar with the signature. There you go. That establishes that you have the knowledge to be able to testify to that particular fact. And when you have a recorded document like a deed or an easement or something like that, if you get a certified copy of the document and you submit it, the document is essentially automatically admissible. I'm maybe overstating that a little bit, except in the cases of claims of forgery and things like that. But it is authenticated as a recorded document. Now, do remember something is that what it has been authenticated for and admitted for is that it was recorded on a particular date. And there's a big difference between getting something in as a particular event that occurred as opposed to what the contents of the document state. The contents of a document that recorded are not necessarily deemed true. It's simply evidence of what the event was. So when you are authenticating recorded documents, do take the extra step of getting a certified copy and submitting it with your declarations. Oftentimes I see lawyers attaching a copy of the complaint and saying attached and incorporated here too is the true and correct copy of the complaint. Well, that $5 will buy you a cup of coffee at Starbucks because that's not admissible evidence. The things that are stated in complaints are not considered to be admissible evidence. Even if the complaint is verified, it's not considered to be admissible evidence. Don't rely upon a complaint. Get your client to sign a declaration that lays out the facts. And the reason for this is that pleadings are supposed to just state ultimate facts and conclusions. And so they are not considered to be evidence, even if they are verified. And for those of you who like to introduce information from the internet, be careful. There aren't many cases on this, but the cases that have looked at this have made pretty clear that there's no official website provision for judicial notice in California. So if you're going to admit something, try to admit something that's from the internet, you better go through a process of really authenticating and laying a foundation as to why that information should be relied upon by the court. It's not an easy exercise by any stretch of the imagination. And don't forget that even if you attach photographs to your declaration, what you need to do is authenticate the photographs because photographs are considered writings, just like anything else. And to be authenticated, you have to lay a foundation, who took it, when the picture was taken, what it depicts. You need to have a witness that actually authenticates what this photograph shows in order for it to be considered as part of the evidence in the case. Another thing that you want to avoid in declarations is stating what the contents of a document is. Which goes something like this. Attaches a true and correct copy of the contract. Under paragraph B of the contract says this. Now that's essentially, you're just reciting what the contents of a writing is. And under the evidence code, I think it's 1522, oral testimony is not admissible to prove the contents of the writing. And you've probably heard the objection, the document speaks for itself. Well, this is the actual evidence code that lawyers use to mean the document speaks for itself. Oral testimony concerning what a document contains, it's not considered to be admissible evidence in most circumstances. There are some exceptions that are covered in the statute, but basically it's not considered to be admissible. All right, so the last thing I wanted to cover today briefly is the subject of opinion evidence. Do be sensitive as to matters of lay opinion and expert opinion. And just 2 quick points to make here. Remember that lay opinion is a pretty narrow area. We don't let lay or witnesses who are not experts. we don't let them testify as to their opinions as to things that we would rely upon an expert to tell us. And so it's limited to things that we allow people to do, such as lay opinion of intoxication. You know, sure looked drunk to me. Well, that could be admissible. Boy, they were really angry. That's an admissible form of opinion, but it's pretty narrow. I know another case here where, you know, driving a motor vehicle at an excessive speed is something that can be admissible lay opinion as well. Gee, I saw that car roll past me. It was driving really fast. That isn't an admissible sort of opinion, but be very careful, because lay opinion is interpreted in a very, very narrow sense in terms of what we allow witnesses to do. Now, if you find yourself in this circumstance, one of the techniques that you can use to get this evidence in is essentially to tell the court that this opinion is essentially a way of summarizing what would be a very large volume of testimony. You know, I've gone through all of these records, and in my opinion, there's nothing in there that says X. That's actually a form of lay opinion that can be admissible if you lay the foundation that essentially you're trying to summarize a voluminous amount of information. So that's something to consider. And then in terms of expert opinions, don't bring in an expert declaration and then forget that the expert has to go through not just what their opinion is, but they have to inform the court how they got at that opinion. Now, the basic rules that an expert can testify an opinion on a subject that is sufficiently beyond the common knowledge that the opinion of the expert will assist the trier of fact. But as I note here in this Bozzi versus Nordstrom case, which is worth reading if you have expert testimony declarations, an opinion is only as good as the facts and the reasons on which it is based. So make sure to go through with your expert the process that the expert reached, what they considered, what they thought was important, what they didn't consider to be important, so that you really give flavor and strength to the opinion of the expert. And with that, I'm going to go ahead and ask Mr. LeHocky to go ahead and take things over. Mark?
Thank you, David. Excuse me, let me make sure I get everybody on the screen here. I think, yeah, we need to just shut down that and then get everybody back up here. Thank you, David. I think at this point, I've been looking, we've not received questions as yet, but please pass anything along that people would like to hear more about. David, that was an excellent summary of the law and the technical requirements that we all have to live under. And for those who are watching, I believe the PowerPoint will be made available to you. I would definitely get it and keep it in your desk drawer as you get opposition declarations in, because it's a great tool to juxtapose against what you see, which often doesn't meet all those requirements. So perhaps at this point, Commissioner Shoker, in your role, obviously with your background, but in your current role and how it really plays out and what you're encountering, we'd love your observations. What are you seeing that's before you that is working? What are you seeing before you that is in the not so much category?
Thank you, Mark. And you know what I'm going to do? I'm going to print out David's slides, have them available on the bench, and ask the attorneys, before you submitting anything, did you read these? If you did, please initial here, and I'll read the document that you're submitting. I think, and the other thing is, none of the CCCBA members are doing things that we're talking about, okay? These are attorneys that are not CCCBA members. Those are the only ones that make these mistakes. One thing that kept coming across during David's presentation, and he said it a lot, like in a better way than I could ever do. Just because you're submitting a declaration and you're typing it sitting in your office does not mean the rules of evidence go out the window. Rules of evidence still apply. So like David kept saying, when you're drafting these declarations, imagine in your head that it's a witness on the stand. And can that witness testify to the things that you're putting in your declaration? And if the answer is no, stop typing right then and there. So what I'm seeing is attorneys putting in declarations, not on behalf of the client, not on behalf of a witness, but they are saying they have personal knowledge of these facts. And if nothing else, even if you don't remember the evidence code, and I don't blame you if you don't, because if you don't use it every day, yes, you might forget. If nothing else, just remember, if you become the witness, then who's the attorney? Right? So if you are writing a declaration saying, I have personal knowledge of these facts, and then I look the paragraph further and it says, because my client called me and told me that yesterday at 7:30, the ex-wife, blah, 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 blah. That is not in your personal knowledge. That might be your client's. Let's get there. And there's nothing wrong with saying, I'm attaching my client's declaration, and have your client write that, or you type it and your client signs it. So I don't understand why that hesitation, saying I don't have personal knowledge, but my clients know. Or for example, in unlawful detainer matters, we get requests for posting orders, which those of you that don't do eviction cases is an order that we were not able to serve the person, and we need to post it on the door and we'll mail them a copy, right? So normally when you get a posting order, you have to make a certain number of attempts to serve the person. And in our county, pursuant to local codes, one of the attempts also have to be during the weekend. But then we get declaration from the attorney saying, we attempted to serve the person on Saturday at 12, and then an attempt was made on Monday and on Wednesday, and I'm signing under penalty of perjury. Well, unless you're the one who was knocking on the door and in the driveway trying to serve the client, why not just say, my office hired this process server, and the declaration from the process servers is attached here too, and let the process server talk about that. There's nothing wrong with it, and you're not being a bad attorney by saying, I don't have personal knowledge. In fact, that's your job. Because if you have personal knowledge, and if there's an issue with that service or posting order, and other side wants to put you on the stand, there's nothing I can do at that point, because you're telling me you were the witness, right? So even if you forget everything else in the evidence code, just remember that part, that do you really want to be the witness in your case? The other issue, two issues, and Mark, then, we can do more questions as well, but two things that I also see, David talked about text messages. That's a big, big issue. If you're doing a declaration that your client is signing, so you understood the evidence code and all of that, you're like, I'm not touching this, I'm going to have my client sign a declaration, and you're trying to bring in those text messages, they should be in their entirety. Mm-hmm. It should not be that, the first 5 text messages that your client responded to were beautiful because your client was talking to the other side in a polite manner, and then your client kind of lost it, but the other side was worse, and you're like, the client deletes all his or her responses. No, there's a gap. And yes, I'm getting old, maybe my eyesight's going, but I know when there's a question, answer, and then there are 5 answers, there's something missing, right? So you are, at the end of the day, officer of the court. Even if you're not intentionally doing it, but when you're submitting a declaration, even on behalf of your client, please take a moment to look through it. Even if it's, in not your intention, the responsibility is still yours. You're the one who's submitting that to the court. And the other thing, which I keep seeing again and again and again, and that is maybe for my sanity or the clerks that happen to open the file, or when you're submitting photographs, Yes, go through all the stuff that David talked about, authenticate them, only submit them. If the pictures are not appropriate, and you all know what I'm talking about, if the pictures are not appropriate, please put the declaration down, really have this conversation with yourself and your client. Do we need to submit these pictures at this point? Or can we just say there are pictures that are not appropriate and that can be submitted if the court wants them, or if the other side is contesting that those exist? Please do not do print paper, 8 by 10 pictures. Because I'm telling you, sometimes we take these calendars right after lunch, and I don't want to look at those pictures right after lunch. I'm just saying it. Because there are other concerns, not just did you establish, all the evidence code rules. It's also, your client might be fighting with the ex-wife today, but they might get back together 2 years from now. And those kids that you're fighting over, your clients are fighting over, if they end up becoming attorneys and pull that file because they want to see, hey, my parents had filed for a divorce one time, I wonder what happened. And they pull the files, trust me, they don't want to see those pictures. And this is not just family law issues. I see that in civil harassment all the time. Just because you can hit print on social media and print all those pictures, and somebody was not smart enough to post those pictures, just don't automatically attach it to a declaration thinking, here we go, our exhibit's done. That's not the way to get those in. So just really think through it. Just because you have a document that might shed a bad light on the other side doesn't mean that you should automatically attach that. And one last thing, as somebody who reviewed motions to compel as a discovery facilitator before, what you put in your meet and confer letters, somebody will find a way to attach that to the motion to compel. So please, please, please be civil. If you are not going to say those things to your opposing counsel in the courtroom, do not put that in your meet and confer letters. You'll be surprised the number of times people do that. Just because you feel like the other side is not getting your point does not call for saying, I understand your law school did not cover meet and confer, or your law school did not cover civil procedure. Here, I'm citing it for you. It does not, it doesn't help your case. Yeah, I mean, on technicality, yes, you might get a ruling in your favor, but guess what? Next time you come to court, I'm going to remember this is how you talk to your opposing counsel. Not that I'm going to penalize you for it, but it's just, it leaves a bad taste. If you cannot, the rules of court ask you to be civil to other side and meet and confer and all of that, and you have certain responsibility to do so. So just watch out what you put in any of the written material. And I promise one last thing, and Mark, then I'll get back to you. The length of the declarations. Just because somebody in your office had a beautiful template, and we all been there when you're a new associate and your senior associate or partner says, don't reinvent the wheel, use what's on the network drive for the office, and you open it and it says a motion to compel and a declaration. You don't have to use the whole template. And I can guarantee you there are only 2 paragraphs in that 50-page motion that applies to your case. And it is okay to just use those 2 paragraphs and then put in the facts of your case. You don't have to use the whole thing. Just because it's a 50-page motion does not mean that you're going to get a ruling in your favor just based on the length of it. In fact, many times it's frustrating to go through declarations and motions and say, these are boilerplates. We've seen it 20 times before. And I'm not trying to put anyone down, because I've done that, and I'm sure, Mark and David and Kate will tell you, we all did that. We were all those new associates that felt the pressure that we need to have a long motion or a long declaration because somebody's reviewing our work. just be careful.
If I can just key off of that for a minute, then I'll turn things over to Kate. Couple of thoughts again from sitting as a discovery referee and master and a arbitrator. I could not agree more that length is dangerous because you can distract your audience whenever you write more than you need to. And one of the things I focused when I was teaching at Davis, now teach at Berkeley, is the importance of brevity. And it's not just brevity in terms of you've got a busy commissioner, busy judge who has many, many matters to deal with besides yours. But invariably, the longer your declaration, just like the longer your brief, you end up mixing in the better points with the less better points and the weaker points. And what you do is you frustrate your neutral, your judge, by them having to read more than they need to when they're too busy. But you're also giving your adversary the tools to attack by putting your weaker arguments in the more kind of extended arguments about what the facts are in there. That's a tool for your other side to say, aha. So brevity is critical. I just pulled up, I don't have it put on the screen, a memo that Churchill wrote in August of 1940 on the topic of brevity. While London was under attack, he sat down to write a note talking about the importance of brevity, because it was to this very point that the longer things are that don't need to be longer, the more you dilute your major arguments. And my last point before I turn it over, Palvir, on this issue of what you're writing, I always remember what I talked to my daughters about many years ago when they were talking about posting things on the internet. I always say the same thing to lawyers. Everything you write is part of your permanent file, and that can be used against you down the road. So if you're writing anything, I always assume it's going to be read by Commissioner Shoker or any judge that we know. And if you write it with that context, I think you will think very differently about the tone. So Kay, we've kept you waiting, and I know these topics that we're just starting to touch on are near and dear. So let's turn it over, and we want all your insights on all these items.
Oh, thank you, Mark and David and Commissioner Shoker. I have already learned so much. It took all I could do to not take notes. And I just kept reminding myself, I'll get the PowerPoint. It's fine. So
we have to pay copyright, by the way. I'm a little worried about that. But
that's right. So thank you, everyone. And I think, Commissioner Shoker, you teed my presentation up beautifully. Because there are other reasons to be truthful in our declarations and to submit appropriate declarations other than just it's the right thing to do, right? So before I dive into truthfulness in declarations specifically, I want to take a step back and look at the big picture, truthfulness in society in general. And I'm going to back up even a little bit more and just discuss a little bit about society in general. And I would suggest to you that even though I haven't been here the whole past century, most of it, I would submit to you that a lot has changed in the last century. The role of women has changed, racial issues, the issue of poverty and homelessness. And I would argue that whether you believe that women have fully attained the rights previously sought, or we still have a long way to go, or whether Black Americans have achieved the height of accomplishment based on merit, becoming the President of the United States, Supreme Court justices, celebrities, leaders of industry, or whether you think systemic racism is plaguing our society, or whether we've made great strides to help those in poverty, or the problem is growing. Regardless of where you fall on the spectrum on any of those issues, I would argue that it's indisputable that these are topics of concern in our society and that conversations are happening and these are considered important topics. I would say conversely, that over the past century, there has been a decline in the commitment to truthfulness in society. Do you know, it used to be that a person's word was his or her bond, and that often deals were made with a handshake, and people followed through, having their yes mean yes, and their no mean no. Of course, there have been bad actors since the dawn of time, so that's not always been the case. But I would suggest to you that truthfulness in our society has stumbled in the streets. And even our news media is biased, and it's hard to know who to trust and who is telling the truth. And I would say that we as lawyers are faced frequently with the situation where people are simply looking for loopholes to get out of what they said they would do. It probably keeps many of us in business. But when it comes to our business, we, as officers of the court, are charged with telling the truth. And if I can screen share, not sure I can do this. I'm going to, well, I'm not sure I can do this. I will have for you from the State Bar of California, Rule 3.3, duty of candor to the tribunal. And in it, it says, it talks about that we cannot knowingly make a false statement of fact or law to a tribunal. We cannot fail to disclose certain things to the tribunal. We are charged with citing appropriate legal authority. We cannot offer evidence that is known to be false, right? Literally, our job is to research applicable law, discern key facts, and present analysis in a truthful way to the court. And then the court makes its decision. And while I would argue that that alone should be reason enough, I thought it might be helpful to know some of the perhaps lesser known consequences of being untruthful in declarations. I will say from personal experience that if I receive something that's untruthful and I know it's untruthful from an opposing counsel, trust is gone. It's completely gone. Recently, unfortunately, it's only happened a few times. Most of the attorneys that I work with are very ethical and civil, and I enjoy working with them, but there are a few. And recently, I literally went line by line in a document that had already been approved of by both sides, that the other side put in final form. And going line by line, I found that a change had been made. And I had to bring it to the other side's attention. I did it respectfully, but it is disappointing when you cannot trust an opposing counsel and you have to take the necessary steps to protect your client. And so I would say, you know, getting your client what they want in sneaky ways and dishonest ways, that's not zealous representation. That is an unprofessional demonstration of a lack of integrity, and it renders you immediately untrustworthy in my book. But it's not my book that you need to be concerned about. It's Commissioner Shoker's book and the judges who sit on the bench. And so I thought it might be helpful to know what some of those judges think about untruthful declarations and what happens. And thank you, Commissioner Shoker. You shared exactly what the theme was. I want to tell you what one judge in Contra Costa County has said. He said that he wants us to know that judges talk. They talk about us as attorneys, and they talk about our cases. They frequently, he used the word frequently, pick each other's brains about cases and attorneys. And he wants us to know that our reputations are the best thing that we bring into the courtroom, and that we should make every effort not to ruin it in front of any judge. And he said, please assume that we all, as judges, are talking to one another. And so I would say that in protecting our own reputations, that truthfulness and civility are key components of that. And I actually teach legal writing in the paralegal program at the JFK School of Law at North Central University. And my very first assignment to students is not a legal writing assignment. It is not teaching IRAC and having a writing assignment using IRAC. My very first writing assignment to students is a general writing assignment. And the prompt is always the importance of developing a positive professional reputation. And I tell them on the first week of class, believe it or not, even though you are only in your second quarter of a legal program, not even law school, your reputation has already begun. The way that you treat your fellow students, the way that you treat your professors, the way that you treat your instructors, talk about them when they're not around, people are listening, and people are forming opinions, and they know. And I can tell you right now, there are people that I went to law school with that I would highly recommend and I would refer clients to in a heartbeat. Hello, Jasmine Jenkins, you're one of those. There are other people that I went to school with that I would not. I would not speak poorly of them, but I would not send anyone in their direction because of the reputation that I believe that they earned in the short time or long time that I've known them. And I really want to end by on that note and saying there's I don't know if any of you have heard of Joe Ehrman. He used to be with the NFL. He was a football player with the NFL. And he became a pastor. And what he did one time is he interviewed a number of people who were in the sunset years of their lives. And he wanted to know what they would have done differently if they had their life to do over again. And he said 3 themes came up over and over and over. And he said that people in their sunset years wished that they had taken more risks, that they hadn't played it quite as safe. 2, they would have treasured relationships more. They would have nurtured relationships and treated relationships, given them a higher priority in their lives. And lastly, that they would like to have lived their life in such a way that they would leave a legacy after they were gone. And I love his quote, one of his quotes, and I will provide this in the materials as well. He says, at the end of our life, we ought to be able to look back over it from our deathbed and know somehow the world is a better place because we lived, we loved, we were other-centered, other-focused. And I submit to you that we as attorneys, our job is to be other-focused. We work for our clients, and our focus needs to be on their best interest and zealously representing them. And we all took an oath when we became attorneys. And I encourage all of you to review that oath, because that embodies the importance of both truth and civility. And I would say that as we move forward together, committed to truth and treating one another with civility, that it is most likely going to be a broken path. We are imperfect people working with imperfect people, sometimes working with very difficult clients. But I would say that the effort that we put into it and the choices to take the high road and do what we've agreed to do with civility will provide for us the very legacy that we would like to leave. And I just want to thank all of you for being a part of our presentation today.
So thank you, Kate. Thank you. So we have about 10 more minutes. I can't help myself but to build off of Kate's comment with regard to candor and credibility. As somebody who sits as both an arbitrator and mediator, I think the most precious thing we have is our credibility. I find it interesting, by the way, in mediations where people focus so much on dollars there's a value proposition. Something's only worth this, something's not worth more than that. And I spend a lot of my time saying, you're not factoring anything else in here, most primarily time. And I'm of a view, you can always get more money, but you can't get more time. But the more precious commodity we all have is our credibility. And been there before too many times in my neutral arbitrator chair too, where people overextend and argue too much, or in some cases cross the civility line, WL line, so much so that when I taught one of my courses at Davis's law school, I told the students up front, if you use certain words, if you make it personal, if you attack, you will be graded down because you're not helping your client. And by the way, I have lawyers still today who'll periodically say, well, I put those words in there because my client wanted me to say those things about the other side. And I politely try to say back, you're not helping your client by doing that. You have to explain to your client exactly what Kate expressed and what we've been sharing today, that to be effective as an advocate, you can attack positions, but do it surgically. You can attack arguments, but do it in a disciplined fashion. But when it becomes personal, your client's position doesn't improve. Your credibility goes out the window if you overstate. And I do encounter those, especially in the discovery world. So, again, going back to the permanent record thing. So we've got, like I said, about another 8 minutes, what we had set aside. I don't see questions as yet. Again,
And Mark, I just want to kind of follow up on the point you just made. It's in legal field, there is this misperception, however you want to label it, that if you're not aggressive, you're weak. And that's been drilled into it from the first day of law school. Then we start practicing, and that's what's been drilled, especially if you're in litigation. Okay? That if you are not aggressive, you're weak, nobody will take you seriously. So, and then people also equate aggressive to just outright mean. Okay, that's a very legal term, mean. Let me, and I think we have many new attorneys here. Let me give you permission right here, right now. You don't have to be mean. You don't have to be aggressive. You just have to know the law. You have to know your facts. That is your job. That is it. If you have those two things on your side, you can be the most passive person. And when I say passive, I don't mean that you don't even speak when it's your turn. I mean, not in somebody's face, okay? You can be kind, you can have a softer voice and still make a huge impact for your client. So this whole idea that you need to be, what Hollywood portrays as litigators and no, you don't need to. In fact, as a practicing attorney, the best results in mediations that I had were when I had the smoking gun, when I had the evidence, in fact, from the other side's expert medical provider that was in fact saying that my client needs surgeries and all of that, that they completely missed. And I had the most impact because I was just being me. I don't have that demeanor where I am in your face and jumping up and down. I just quietly moved their report over to their table. So if your senior partner is telling you that you need to be more aggressive, that might work for some people. Some people, that's just their style. But if that's not your style, don't take that on because you think you're not being a good lawyer if you're not being obnoxious. That's not how it's done. And other thing I wanted to mention is, if you listen to this program and you're like, what do I do now? This is all overwhelming. I am never submitting anything to court again. That is not our intent. Look, we all learned, right? Nobody just got up one day, came out of law school and knew how to do any of this stuff, right? We all learned. And if you're sitting there and you're about to put your declaration together and you're stuck and you looked at the Simons and you looked at the evidence code and you don't know which way to go, don't call me, but call David, call Kate, right? Ask them. And that's the beauty of these bar associations. That's the function of our bar association and other organizations, is reaching out to other attorneys who have been practicing for a while. And I will guarantee you, nobody's going to deny your phone call. They will always take your phone call and just say, listen, I won't take time for small talk, but I have this question. Can I put this in a declaration? And it takes literally 2 seconds for somebody to answer that question. So reach out to people. Trust me, nobody's going to say no to you. We all have huge egos. And when somebody's calling us for advice, we're jumping on it, okay? I cannot take those phone calls because, there's that title before my name apparently now, so I cannot answer those questions, but other attorneys in the Bar Association can. So reach out make that network, reach out to other attorneys.
Thank you, Commissioner. That's great additional insight. So with our remaining 5 minutes, David and Kate, any concluding thoughts?
Well, I want to jump in with earlier, Commissioner Shoker made a comment about meet and confer letters. And since I do work as a discovery facilitator for Contra Costa, I just want to echo the fact that when I get an assignment, part of what I want to see is the meet and confer letters. And I look very carefully about the tenor of the letters, but also I'm looking at whether the parties are actually trying to pursue a solution as opposed to just saying, I'm right, you're wrong. And particularly in the framework of discovery, you're trying, the courts want you folks, in other words, us, to work it out and figure it out. They don't want to have to deal with issues. So unless you have a critical discovery issue, don't sit there and say the code says this, the code says this. Work it out, figure out a way. If they want this information and there's some sort of tangential relationship to the case, just give it to them. Don't worry about it. Just move on to things that are important. You spend an extraordinary amount of time and effort, pursuing issues in the pursuit of zealous advocacy. But I think zealous advocacy involves picking your arguments and picking your battles. And sometimes I see counsel wanting to fight about every single little thing. And that's an indication to me that this particular counsel does not have the experience to know which are the important fights to fight and the things that you just should let go. But do note, I completely agree with what Commissioner Shoker says in terms of meet and confer letters. And I look at those very, very carefully as part of it being a discovery facilitator.
And just a quick two seconds, and I'll hand this last comments to Kate. When I act as a discovery referee or special master, I require that the meet and confer either be in person or via Zoom. The letters are helpful, but I want people to go through that human effort to try to solve the problem by having a face-to-face conversation. Unfortunately, there is the tendency to default to the nasty gram. as opposed to making a real effort. But if you're in a room together, remember what that used to be like, or at least doing this, I think most of the time people make more effort than just simply, I'm going to write a letter and to disagree with their letter. So I highly recommend that, even if you're not required to do it, offer to do it to the other side. You'll always look better to the court or your discovery facilitator, your referee, your arbitrator later on if you've made that effort. Kate, last word is yours.
Thank you. Wow, and David, totally agree. This has been very valuable for me. Thank you, everyone. My last thoughts is, and I've had to put this into practice myself, when I have had, I'm going to even say bullies on the other side. You know, there are some attorneys who, as you were saying, Commissioner Shoker, they think they need to be mean. We do not need to let other people's actions, we don't need to give them the power to change who we are as people. And so I make it my practice to respond to every email or every phone conversation, speaking in any phone conversation, to treat the other person with dignity, because regardless of the choices they make, I get to make my own choices. I even had an opposing counsel when I started threatened to have me disbarred. And, you know, I was very polite in my reply, and I called my mentor and cried. And she's like, I know this attorney. This is what this attorney is trying to do. This attorney has his reputation in the community. Just keep taking the high road. And so, so we all get to walk our own paths, and may we do so walking in the light.
Thank you, Kate. And I think everyone has access to the chat, but I want to acknowledge Judge Richard Flyer's comment where he says, my mentor many years ago told me on my first day at a new law office, the most important aspect of your work as a lawyer that you have total control over is your reputation. Always remember that in your work in and out of court. Is a very, very distinguished member of our bar. I want to thank Judge Flyers for his input as well. So Ann, back to you.
I would like to thank all the distinguished members of our bar who are on this panel for showing up today and for giving us a lot to think about. We learned a lot today, and some very thoughtful comments. And yeah, we need to be reminded every once in a while, right? So I think it's good. I'd like to thank David for a wonderful PowerPoint and presentation, Kate for her thoughtfulness in her words, and Commissioner Shoker and Mark for showing up under some exigent circumstances today. So we really appreciate everyone being here. And thank you all for attending. Your attendance certificates and the PowerPoint and some materials will be sent out. And that's my last word. Anybody
Great.
else?
Well, thank you so much.
Thank you, everyone. Have a great
honor to join you all.
Have a great
Thank
weekend.
You too. Bye-bye.
Bye.
Oh, it's the beginning of the week. Have a great rest of the week.
Yes.
Thanks.
Bye.
Bye-bye.
Bye-bye.